The report of the Center-State Relations Inquiry Committee, Government of Tamil Nadu, 1971, read by Ramani, Chapter 11, Territory of the State. Articles 3 and 4(2) of the Constitution are material for a consideration of this topic. Those articles run as follows. Quote, Article 3, formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, a. form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. B. Increase the area of any state. C. Diminish the area of any state. D. Alter the boundaries of any state. E. Alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified in the reference, or within such further period as the President may allow, and the period so specified or allowed has expired. Explanation 1. In this article, in clauses A to E, state includes a union territory, but in the proviso, state does not include a union territory. Explanation 2. The power conferred on Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Unquote. Quote, Article 4, laws made under Articles 2 and 3 to provide for the amendment of the first and the fourth schedule and supplemental, incidental, and consequential matters. 2. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of Article 368. It will be seen from the discussions in the Constituent Assembly that there was a strong feeling expressed by some important members of the Assembly that the consent of the state concerned should be obtained before the Government of India undertook to alter the boundaries, name, etc. of the state. It will also appear from those discussions that the principal reason which weighed with some of the members who supported the official draft was that the then existing boundaries of the units were neither logical nor natural nor based on any known principle, and that some device should be formulated so as to secure powers for the Union government to redraw the political map of the country without being hampered in the process by the attitude of the units. The provision, as finally embodied in the Constitution, merely laid down that the views of the legislature of the state concerned should be obtained. This provision has been further altered, and according to it, it's not even necessary to ascertain the views of the state. All that the central government need do is to simply refer the matter to the legislature for expressing the views of that legislature within a specified period, and Parliament, after the expiry of the period, can straightaway enact the relevant bill, whether or not the legislature expresses any views and without regard to the views expressed by the legislature. The constitutional implications of Article 3 have been dealt with by the Supreme Court in Babulal Parate versus State of Bombay, AIR 1960 SC 51, and State of West Bengal versus Union of India, AIR 1963 SC 124, at pages 1255 and 1274. In the first case, S.K. Das, J., explains the implications of the above provisions thus. Quote, the proviso lays down two conditions. One is that no bill shall be introduced except on the recommendation of the President, and the second condition is that where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has to be referred by the President to the legislature of the state for expressing its views thereon. The period within which the state legislature must express its views has to be specified by the President, but the President may extend the period so specified. If, however, the period specified or extended expires and no views of the state legislature are received, the second condition laid down in the proviso is fulfilled in spite of the fact that the views of the state legislature have not been expressed. The intention seems to be to give an opportunity to the state legislature to express its views within the time allowed. If the state legislature fails to avail itself of that opportunity, such failure does not invalidate the introduction of the bill, nor is there anything in the proviso to indicate that Parliament must accept or act upon the views of the state legislature. Unquote. The contention that Article 3 should be construed with reference to the doctrine of democratic process was repelled, and the difference between the provision in the American Constitution and our Constitution pointed out. Quote, in plain and unambiguous language, the proviso to Article 3 of the Constitution states that where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill must be referred by the President to the legislature of the state for expressing its views. It does not appear to us that any special or recondite doctrine of democratic process is involved therein. Learned counsel for the appellant has invited our attention to Article 4, S. 3 of the American Constitution, which says, inter alia, that, quote, no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. Unquote. That provision is quite different from the proviso we are considering. The former requires the consent of the state legislature, whereas the essential requirement of our proviso is reference by the President of the proposal contained in the bill for the expression of its views by the state legislature. We see no reasons for importing into the construction of Article 3 any doctrinaire consideration of the sanctity of the rights of states. Unquote. Sinha, C.J., who delivered the majority judgment in the second case, set out the position as follows. Quote, what appears to militate against the theory regarding the sovereignty of the states is a wide power with which the Parliament is invested to alter the boundaries of states and even to extinguish the existence of a state. There is no constitutional guarantee against alteration of the boundaries of the states. By Article 2 of the Constitution, the Parliament may admit into the Union or establish new states on such terms and conditions as it thinks fit, and by Article 3, the Parliament is by law authorized to form a new state by redistribution of the territory of a state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. Legislation which so vitally affects the very existence of the states may be moved on the recommendation of the President, which in practice means the recommendation of the Union Ministry, and if the proposal in the bill affects the area, boundaries, or name of any of the states, the President has to refer the bill to the legislature of that state for merely expressing its views thereon. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its powers and authority. Unquote. Subbarao J., as he then was, in a dissenting judgment, observed, Quote, it is said that Parliament can destroy the state under Article 3 of the Constitution, and therefore nothing more untoward can happen to a state if this limited power is conceded, as a larger power has already vested in the Parliament. Article 3 only enables the Parliament to make a law for the formation of a new state, alteration of boundaries of any state, increase or decrease of the area of any state, or alteration of the name of any state. Such a power is expressly given to the Parliament, and therefore it can function under that article. Unquote. Thiru Ashok Chanda in Federalism in India comments on this point as follows. Quote, it's important to note that the Act does not enjoin that the concurrence of the state legislature should be obtained or the wishes of the people ascertained by a referendum as a prelude to parliamentary legislation. It merely prescribes that the President should refer the bill to the states. The legislation itself does not require that it must be passed by a two-thirds majority of members present and voting, or that an absolute majority of the total strength should be obtained in addition. It is sufficient to have it passed by a simple majority. In other words, the provision is treated as falling within the scope of ordinary legislation and not of constitutional amendment. The existence of this provision had thus enabled the Dominion government, even before the Constitution had come into force, to order the enlargement of the area and alteration of boundaries of the state of Bombay and the absorption and exchange of enclaves elsewhere for the convenience of administration. This article, as now amended, gives Parliament, in other words, the party in power at the centre, the right to undertake a reorganization of the states without their consent and without even waiting to ascertain their views. In the United States of America, the formation of a new state involving adjustment of territories of one or more existing states is permissible only with the consent of the legislatures of the states affected. In Australia, the approval of the majority of the electors of the states is required in addition to the consent of the legislatures. Herein lies the basis of the concept of the indestructibility of a state in a federation. The Indian provision is thus unusual, dispensing, as it does, with the concurrence of the states affected as a prerequisite of reorganization. Unquote, pages 46 and 47. It may be useful in this connection to refer to similar provisions in other federal constitutions. By Article 5 of the Federal Constitution of the Swiss Confederation, the territory of the cantons is guaranteed by the Confederation. Subsection 1 of Section 3 of Article 4 of the American Constitution provides that no new state shall be formed or erected within the jurisdiction of any other state, nor any state formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned. sections 123 and 124 of the Commonwealth of Australia Constitution Act go a step further, and according to those sections, not only the consent of the legislatures of the states affected is necessary, but the approval of the majority of the electors of the state also is required. The Constitution of the German Reich 1919 also required the consent of the states for alteration of their boundaries. Again, Section 3 of the British North America Act 1871 empowers the Canadian Parliament to increase, diminish, or otherwise alter the limits of any province only with the consent of the legislature of the province, and that too only upon such terms and conditions as may be agreed to by that legislature. Although the South African Constitution is said to be unitary in character, it prohibits Parliament from altering the boundaries of any province, dividing a province into two or more provinces, or forming a new province out of provinces within the Union, except on the petition of the Provincial Council of every province whose boundaries are affected thereby. See Section 149 of the South Africa Act 1909. The linguistic states were formed to satisfy the aspirations of the entire nation and to facilitate the working of the organs of the state on a wider democratic basis. Now that the boundaries of the various states have been refixed in accordance with the sentiments of the people concerned, it's but natural that provision should be made to safeguard the territorial integrity of the various states from undue interference by the center. It's not difficult to imagine a situation in which a party which has no belief in a federal setup and which is pledged to the setting up of a unitary government for the whole country captures power at the center. If this eventuality fructifies, there is nothing in the Constitution to prevent the center from doing away with the linguistic division of the states, or, for that matter, to single out any particular state for absorption in any neighboring state, or from converting it into a centrally administered area. All this could be achieved by a simple act of parliament passed by an ordinary majority, and the state will be helpless. One of the essential points of the federal principle is that the central or the national government should not have the power to unilaterally redraw the map of the country by forming new states or by altering the boundaries of the existing states. It was originally provided in the draft constitution that the consent of the legislature of the state concerned should be obtained before altering the boundaries, name, etc. of that state. Considering the current disputes regarding the borders between various states, it may not be advisable or expedient to insist on the consent of the states for the alteration of their boundaries. In the replies received to the questionnaire issued by the committee, a suggestion has been made that disputes relating to borders between two states should be decided by an independent judicial tribunal consisting of retired judges, and that the decision of the tribunal should be made final and binding. But it should be noted that instances are not wanting where the awards made by commissions presided over by retired judges of the Supreme Court and High Court on the border disputes have been totally disregarded or substantially modified. Two alternatives are open. One is to provide in the Constitution for the consent of the states concerned being obtained on the analogy of similar provisions in the constitutions of the federations of the traditional type, or to set up an independent judicial tribunal for deciding the issues. If either of the above alternatives is found unacceptable, it's for consideration whether it may be provided that the opinion of the people of the area concerned should be ascertained. A similar provision is to be found in the Australian Constitution, though this is in addition to the consent of the Parliament of the state concerned. In our country, this method was employed to ascertain the wishes of the people of Goa on the question of the merger of that territory with Maharashtra or Gujarat. See the Goa Daman Opinion Poll Act 1966, Central Act 38 of 1966.